All right, so you just heard former President John Mahama and the NDC's 2020 presidential candidate. He has been speaking about the election petition. He explains why the NDC, or he has decided to challenge it. One of the main things he said, which stands out for me, is that he says, why am I doing this? I want the same thing my opponent wanted in 2012, the removal of doubt. Joining me in the studios are court correspondent Joseph Akable, and he actually has cited the petition that was filed earlier today at the Supreme Court. Thank you very much, Joseph, for joining us to do this. So you have been through the petition, and we'll come to the petition, but also I'll be joined by Evans Mensah and then some other, we're also trying to raise some of the NDC lawyers, or the lawyers who have been designated by the NDC to speak on the party's behalf, so we can get into the petition proper. So Joseph Akable, you have heard the former president, and you have also seen the petition that has been filed at the Supreme Court. What would you want to take away from what the former president has had to say?
I think first and foremost, it was an important address, in that we need to look at it in the context that the NDC got more than 6 million votes. And so there are lots of people who voted for him, who are looking forward to hear from him and understand what is the next line of action, because he has spoken twice. One, he said that they had a clear majority. That was before the announcement from the EC came. And the second time, he says he disagrees with the results, and he has asked that the auditing should take place. And so people are wondering what happens next. We voted for you. We need to get some answers. And so he's now come to explain the steps that he's taken as an individual. What sticks out for me is the reference to the 2012 situation.
All right.
Back then, not many people understood what Nana Akufo-Addo, the then candidate, opposition leader, was undertaking. A lot of people criticized the action that he's taking. And it's interesting that Mr. Mahama makes reference to it to make the point that he wants the same results, and that is to remove doubt. It tells you that, one, he's unsure of the results as was announced. He has issues. And the petition, interestingly, earlier today, the lawyers had given us the sense that he would be speaking to the petition, but that is not what actually happened. He ended up speaking in general terms about the principle of voting and how the issues will be affected. But the petition makes the point that they've analyzed the constituencies, some of them, and they claim that they've identified pardon. And so clearly the team that he set together to look through it came with him with findings that gives him reason not to believe that he lost the election as was announced by the EC. And so I find that to be very important, and it's worthwhile he's speaking to the nation and his supporters and saying that, look, I have my doubts. I want those doubts removed. And it's important that we all agree that it's the Supreme Court that can help remove that particular doubt. And so he's taking the step to take the matter over to the Supreme Court. And I thought that was quite instructive.
All right, so we will come to this, or let's actually go into the petition right away, because you have a copy of it. Before then, though, let me also bring on Samson lardy, Anyenini, legal practitioner. Samson joins us once again. Hello, Samson. So you have heard the former president. We're expecting or anticipating that he was going to give us some details from the petition. We didn't quite get that. But what do you take from what he's had to say?
So once he's put his foot in the courtroom, he's not allowed to run commentary to suggest the merits of his case. It's not allowed in law. So it is understood the manner in which he approached it without seeking to get into the merit. The centrality of what he said is what Akable just pointed to: removal of doubts. And he, for the obvious political purposes, he refers to the 2012 or 2013 petition to let people remember that when President Akufo-Addo found himself in a similar circumstance, he also took the decision to go to the court. The point that has to be made is that in this maturing democratic experiment, you practically have no option. You do not have an option if elections, don't go your way, and you have found some evidence that some wrongdoing, there were some infractions of the law, and more particularly, election results are overturned on one major principle established across the world, that the number of votes that one seeks to annul will make an impact, will make a significant impact on the results. If the number of votes that you're seeking to annul will not make an impact, then it will be a fruitless exercise. Now they have clearly demonstrated from the content of their petition, they've gone through the arithmetic and suggested that neither President Akufo-Addo nor President Mahama obtained more than 50% as required by Article 63 Clause 3. And when that happens, the Constitution provides further that the two who had the highest votes must go to a runoff, a second voting exercise. So they have made it clear that's all they seek, and they want to start with the Supreme Court to annul the declaration by Jean Mensah, the EC chairperson, on the 9th of December as gazetted, and the gazette notice that we know on the 10th of December, which is the constitutional instrument 135. Once that constitutional instrument 135 2020 is annulled, that is, if their evidence is tested. Now, Israel, remember one thing too. They've been talking about some of the evidence they have. They talk about padding and so on and so forth. That is their story. And at this point, it is still their story. It will now go through the mail. It will be tested in cross-examination, tested in arguments, superior arguments. If their evidence and their argumentation survive the test of judicial scrutiny, then they will win. But if the opponent brings a superior defense, it is also possible that they will not win. And justice will not mean, as he says, justice will not mean that he wins. And I think it's instructive that he says removal of doubts.
Yeah.
By the time the doubt is removed, it will not mean that he is winning. It could be that he is winning. It could also be that he's not winning the case. Justice must not mean that I am going to court, therefore I should win. The processes, let their evidence go through the test, and let's see if it survives. The testimony, the sworn statement that he has put out in the courtroom will also go through a scrutiny, an examination. And in the end, there will be a judgment. All of us, thankfully, will follow a live telecast of the proceedings, and we will also make our own judgments. In the end, when we study the judgments delivered by the courts.
All right. Now, something there's something that's quite instructive, and it tends to happen in most of these cases that come up, that the arguments that are made before they actually show up in court often tend to be very different. So then before the courts, you hear a lot of commentary about what they are seeking. But then when you look at the petition that eventually ends up in court, it is quite significantly different from the arguments that are made in the court of public opinion. I'm sure you have come across that in this petition as well.
Absolutely right, Israel. We have heard words like stolen verdict. We have heard expressions like fictionalized and flawed. Those may sit within the present suit. But when you heard claims that by the NDC's own computation, President Mahama had secured a win, and that he ought to have been declared the winner. Then you read the petition, and it says President Mahama did not win, Akufo-Addo did not win, because neither made or crossed the threshold of 50%, more than 50% of total valid votes. Therefore, there ought to be a runoff. That is a dramatic shift from what you see in the court. So you are right, Israel.
Yeah. And Samson, I'd like you to hold on at this point. I'd come to Joseph Akable, who has a copy of this, to go to that part of the petition where they indicate what exactly they're hoping, or they believe that President Akufo-Addo would have gotten, and what the NDC candidate John Mahama would have gotten. And that puts everything in perspective. So they're not indicating that the NDC or John Mahama is not indicating that he got more votes than President Akufo-Addo. He only goes to say that if you look at the numbers and if they do their own collation, it turns out that President Akufo-Addo is not going to get the required number of votes to put him above 50%. Joseph, can you have you seen that?
In fact, there is so what they do is that they trace series of communication that came from the Electoral Commission, and so the first one, the EC chairperson, the statement she read, then that made reference to the total valid votes that subsequently changed.
Yes.
And so they trace it from that point to use those figures to say that, I mean, in effect, when you look at that computation that was done, if it's done as accurately as it ought to be, you will not have any of them are getting more than 50% of the votes cast. And so he says that it makes reference to Techiman South constituency having a total registered voter population of 128,018, and if added to the total valid votes announced by Mrs. Jen Mensah as cast, the resultant figure will now be 13.5 million. Consequently, he says if all votes of the Techiman South constituency were added to the petitioner's votes, second respondents' votes would remain the same at 6.7 million, now yielding 49.625%, while the votes of the petitioner would increase to 6.342,907 million, now yielding 46.768%. And so in this particular instance, you see that contrary to the point, and that's what Samson has said, that they had put out a narrative that they had won the election, and now in terms of going to court and going through the documents and what they've discovered, they are saying that no one got more than 50%. And it's on that basis that they are saying that the declaration was unconstitutional because no one got more than 50%, yet someone was declared as the winner.
And in the petition as well, just before this paragraph, there was that part where they make reference to the declaration by the EC chairperson and the fact that she had used the total number, she indicated a certain number of total votes cast. And they are making reference to that particular figure to say that, yes, if you take that as the total valid votes or the total votes cast, and you're adding if you add the Techiman South results, then it's going to result in what if you could just get to
yes, we'll come to that. There's another interesting point. They actually make reference that even using the EC's own figures,
yes,
Mr. Mahama's percentage is actually lesser than what was announced for him. And so that is from the point 10 here. It says, from the total valid votes cast of 13.4 million, petitioner's percentage would be 46.260 and not the 47.366 erroneously declared. So 47.366 higher, that was what was declared for him. They are saying that if you use the EC's own figures and do the math right, it should have actually been lesser. That is 46.26.
But it's also significant to indicate that at this point, the 13.4 million that is used in the petition, this was as declared by the EC chairperson on that night, which the EC came back to correct, that it was inadvertently used. But that has found its way into the petition, and this is one of the arguments that's been made by the lawyers for former President John Mahama.
Yes, and on the Techiman, that portion of the petition says currently the election results, so they quote what the EC chairperson has said, that currently the election results we have declared exclude that of the Techiman South constituency with a voter population of 128,000. They said election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it will not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techiman South. Now they make the point that the Techiman South has a total registered voter population of 128,018 as the AC chair announced. And if added to the total valid votes announced by Message and Mensa as cast, that's a 13.4 million figure, the resultant figure would now be 13.56 million. Consequently, if all the votes of Techiman South were added to the petitioners' votes, second respondents' votes would remain the same at 6.7 million, now yielding 49.625%, while the votes of the petitioner would increase to 6.3 million, now yielding 46.768%.
All right, I'll go back to Samson Anyenini, who's still with us on the Zoom. Now, Samson, so one of the issues that has come up has to do with the declaration made by the EC chairperson on the night when she declared the results of the presidential election. Now, day later, or the EC later came up, in fact, the day after, they came out to say that the EC chairperson inadvertently used total valid votes, or actually announced total votes cast when she was supposed to have said total valid votes cast. So there's an error that came out at that point. When this case goes before the Supreme Court, which figure is the Supreme Court going to use? Are they going to use the declaration as was done publicly, or what eventually was gazetted?
So we cannot try to do the case for any of the parties.
All right.
Not for the petitioner and not for the respondents. The petitioner is urging the court, as we find on its documents. The respondents will reply.
All right.
In the reply, they will say what you just said. And they might ask the court to ignore the error as made in the declaration and rather rely on what the correct figure that she should have read. They will say so, but the petitioner is entitled to also say what he has just said, because what he says is a fact. Whether it was subsequently corrected or not is a fact. The respondents must defend what happened in the courtroom, and then the panel of judges will make a determination. And as we saw in 2012, we certainly are going to see a full panel. We are not going to see a small number of a panel. This is not the kind of case that the Supreme Court will take one judge to sit on. It's not the kind of case that, and you know, there are cases that one judge of the Supreme Court can hear for and on behalf of the entire Supreme Court. It's not a case that you will have a panel of 5 sit on. No, they will make the full panel. And so we are going to see what we saw in 2013 play back. We'll have as many as 9 of them get on there, and they will make the determination. If they disagree, they will vote and show clearly where, you know, each person belongs. In the last election petition, something interesting happened. The NPP alleged overvoting, among other things. Polling stations without serial numbers, duplicate serial numbers, or polling stations without codes, and so on and so forth. The tables nearly turned, and this is where it nearly turned. There were 2 3 judges who agreed that overvoting had in fact taken place, and they had ordered the annulment of a certain quantum of votes and rerun of the elections in those places where the votes had been annulled. There was a situation where the annulment of a quantum of vote would have culminated in neither Akufo-Addo or John Mahama securing the constitutional more than 50%, which would have meant a runoff.
Yeah.
All they needed was 2 other judges to agree with them, and things would have changed. That's all they didn't get. So the judges will exercise their independent minds, and they will determine, after they have heard the arguments and testimonies, cross-examinations of all these. I do not know if issues of cross-examinations will come up, but it looks like it will be central. The reason I say that is that in the courtroom, when we are fighting a suit on what is known as affidavit evidence, we normally often don't, give testimonies, as in call people to sit in the box and to talk in addition to what they have filed. But despite the affidavit evidence that was tendered the last time, the court still decided that they had to hear viva voce, as in oral testimonies and cross-examination going on. I suspect the same thing will happen, but it will be determined on the 10th day, when all the parties will be summoned. They'll be giving a 2 days notice to appear before the court for a process known as the pre-trial conference. At the pre-trial conference, the court will narrow all the issues in the suit into either 1 or 2 issues, which will engage its minds to make a determination. It is at that stage that they will try to tick the boxes. Petitioner was supposed to do this. Have they done it? Respondent was supposed to do this. Have they done it? And check if everything is in order. Once all of that is determined, then they will also determine how many witnesses is somebody going to call. Party A, who and who are you going to call? What sort of evidence is the person bringing? And they'll make all those determinations. And later we'll get to know the manner in which the case itself will be conducted in the court, including whether or not John Mahama will be put in the witness box.
Yeah, that was something I was going to come to. So you're saying that you may present in your petition a number of people you'd want to call as witnesses, and I believe that's what former President John Mahama has done in this particular petition. He's actually indicated people
that's the petition.
As in witnesses he's going to call. All right.
Yes.
So he may, even though that may be indicated, he can still come back and say that, or the courts will decide that you may have, or you may want to call 5, but I'm giving you an opportunity to bring only 2. Is that the case?
Yes, during the pre-trial conference, a lot of things can happen, including the exact witnesses that may be called. Who may be called, who may not be called. All these things will be decided. What sort of evidence is going in, or what sort of evidence is not going to be included. All of this will be determined at the pre-trial conference, which we now call the case management, conference. So they will manage the case at that point. So they know ahead of time. Somebody is coming to use 2 days. 1 day is going to do 30 minutes each day, or 1 hour each day in a cross-examination. Somebody will be using, what do you call it? Will use, is it a prompting device, or will project?
As a teleprompter?
Yeah, somebody will project, not teleprompting, will project something that they have to do, and so on and so forth. All these will be determined at the pre-trial conference, which is by the 10th day. And then the court will now say the 15th day, which is now set in the law. By the 15th day, the trial will start, and the trial will end on the 21st day. Now it is set out in law. On the 21st day, the trial must end. This is what we didn't have in the old amendment, which is CI 74. But in this CI 99, the trial will start on the 15th day and it will terminate. It must end on the 21st day. And then between the 21st day to the 42nd day, the judges will get into caucus, deal with their rulings or decisions, and then come forward to tell us their decision. For example, in the pre-trial, there could be a determination also whether there will be an external party called upon to do some auditing. Like in the last time, KPMG was called upon to audit the pink sheets. All these things will be determined ahead of time so that there's no any ambushments. There's no piecemeal litigation, so to speak.
All right. Is it possible that the auditing of the pink sheets or the results could or may fundamentally change the way the election or this petition may go, or the case may go? That is, if they bring the audit or they ask for the audit to be conducted and they find out some significant, or they tend to find out that the difference between what the EC declared and what the auditor found out, they may decide that, okay, probably this is where the case ends. Could they use that to determine the case, or they'll still want the arguments to continue?
Right. So if an auditor will be appointed, the auditing entity will be giving clear terms. There'll be a clear terms of reference to deliver on answer specific questions to the courts. When they bring their answer, it will form part of the body of evidence to inform the decision of the court. It will not terminate the case at that point.
All right. All right. And I'm bringing that in because that's one of the things that the NDC has been pushing. They're saying that they would want an independent audit of the results, and that if that is done, or if the EC would grant them that, they probably may not. Well, I don't know if they actually indicate they may not vote.
The only time the case may be prematurely terminated will be at the very start, if any of the respondents or the defendants, call them, take the view that the petition has missed a very important procedure or substantive legal process in approaching the courts, and therefore it has to be thrown out. Then they will make that case. Hitherto, you could make that case sometime as the case commences and proceeds. But by the new rules, if you have any such objection, call it preliminary legal objection, you are required to raise it along your delivery of your answer, which you are supposed to deliver within 10 days from the date when you have been served with the petition.
All right.
And you deliver the preliminary legal objection, and then you advance your argument also on paper. So let me give a clear example. Where the law says, if you are fighting an election result, you must come by a petition. If you defaulted or you erred and came by a writ rather than a petition, the other party is entitled to ask the court to throw you out, and the case will be prematurely terminated without traveling the full time that it has to travel.
All right.
Yeah, so today is a deadline that the Constitution, Article 64 says you must file from the date of declaration. They have 2 days. The court has 2 days within which to deliver the documents to the respondents, the President Akufo-Addo and the Electoral Commission. So by Friday, we expect that they would have received it. If they don't receive it by Friday, for some reason, because they cannot be found or they are dodging or something like that, they are evading, the court will give out a process known as substituted service very quickly. And the rules say that they will be published, the processes will be published in 2 national dailies. The court can also determine some other means by which it can reach them. Once they receive it, then within 3 days, they will file what is known as the entry of appearance, which is an acknowledgement that they have actually been served. Then within 10 days, they will file their answer. If you want to throw the case out before it is prematurely, you must add the arguments you want to do immediately.
All right.
Before we go through the various steps one by one until the 42nd day when the case will be fully dealt with.
All right. So we have limited time, and so I'd want us to go to the crux of the petition and the reliefs that the former President John Mahama is seeking. And so we'll start with A. It says a declaration that Mrs. Jean Adu-Kwemensah, chairperson of First Respondent and the returning officer for the presidential elections held on December 7, 2020, was in breach of Article 63.3 of the 1992 Constitution in the declaration she made on 9th December in respect of the presidential election that was held on 7th December 2020. Now, I'd want you to just explain to us in plain language what this means, or what former President John Mahama is seeking here.
Yeah, this relief is a commencement relief.
All right.
But it is the evidence that will be adduced and tested in court that will determine whether they will get it. They just want the court to make a declaration to say and to confirm that neither candidate got more than 50% of the votes.
All right.
Therefore, Jean Mensah, the chairperson, erred in law by declaring Nana Addo Akufo-Addo as the president-elect. If you don't get more than 50%, you cannot be declared as president-elect. That's all they are trying to say.
All right, so we'll go to the second relief, and I'd like Joseph to do us the honor. So B, where it talks about a declaration based on the data contained.
Yes, so it says a declaration that's based on the data contained in the declaration made by Mrs. Jean Adu-Kwemensah, chairperson of the First Respondent and a returning officer for the presidential elections held on 7th December 2020. No candidates satisfied the requirements of Article 63.3 of the 1992 Constitution to be declared president-elect.
All right, so Samson, I guess this is very similar to the first one where you were indicating
this is an affirmation. They are seeking for the court to affirm, double confirm that nobody actually met the threshold.
All right.
The third one is that a declaration that the purported declaration made on 9th December 2020 of the results of the presidential election by Mrs. Jean Adu-Kwemensah, chairperson of the First Respondent and the returning officer for the presidential elections held on 7th December 2020 is unconstitutional, null and void, and of no effect whatsoever.
All right, Samson.
Right. So for as long as the Article 63.3 threshold has not been met, they want a further declaration that that declaration is null and void. So the court would have first made one declaration that they have found as a matter of fact that the Article 63.3 has been breached. Then B, that in fact nobody had more than 50%. Then 3, because 63 has been breached, and that in fact that is in law Then second, that in fact, nobody got more than 50%, the declaration is null and void. The declaration of President Akufo-Addo as president-elect is null and void.
The next one here says an order annulling the declaration of President-elect Instrument 2020 CI 135 dated 9 December 2020 issued under the hand of Mrs. Jane Adukwe-Mensah, chairperson of the first respondent and the returning officer for the presidential elections held 7 December 2020 and gazetted on 10 December 2020.
So this is practically legal propriety and being conscious of a certain chronology. So after you have done A, B, and C, in D, they are saying that there is an instrument issued, a constitutional instrument issued, which is CI 135 2020. It is that constitutional instrument that makes President Akufo-Addo president-elect.
Right.
Now, cancel that instrument. That's it.
The next one, quite interesting. They want an order of injunction restraining the second respondent from holding himself out as president-elect.
All right, and I want you to read this and the following.
The next one here says
well.
An order of mandatory injunction directing the first respondents to proceed to conduct a second election with petitioner and first respondent as the candidates as required under Article 663, 4, and 5 of the 1992 Constitution. In actual sense, they are referring to the second respondent.
Right. So that's
by relief E, they are simply saying that once you have cancelled or declared the instrument that declared him president-elect null and void, go further and injunct him from projecting himself and telling anybody anywhere ever that he's a president-elect.
Okay.
That's as simple as that.
So,
and then the final one is that give us a runoff.
All right, so with the bit that he's supposed to, the court should stop him from holding himself out as president-elect, which is the question I asked you earlier. Does that mean, or does that qualify as an injunction that should stop President Akufo-Addo's swearing in for a second term? You have answered that, but for the benefit of those...
Since it is a relief that can only be granted at the end of the case, that's self-explanatory. It will be granted at the end of the case. If you wanted to stop him from being sworn in, then you will have to go further by filing an application and asking the court to restrain the Electoral Commission, to restrain the Chief Justice from swearing him in. But again, that is almost an impracticality. It's almost an impossibility because by the architecture of our Constitution, there must not be a void at any time. There must be a president at all times. Therefore, the president will be sworn in, but once the petitioner is successful and he is declared as not having been validly elected, then the status quo, he reverts to the status quo as a candidate. And when he reverts as a candidate, he should not be holding himself out to anybody as the president-elect. So that's it.
There's something I noted. I don't know what Samson thinks of that. The hearing is to start on the 15th day. It terminates on the 21st. Then by the 42nd, judgment comes in. And so you see that there are 6 days for hearing and 18 days that the judges have to render their decision. So it appears they are shifting the focus from the drama in the courtroom to more of what you be putting in the court in terms of writing, which will essentially be what the judges within those 18 days will be looking through. I don't know whether that is his own reading of that particular provision as was passed in terms of the new regulation.
Yeah, and Samson, while you take on, when you take on that one, I'd also want to ask, are we going to seeing that we have a lot more days for the judges to come out with their ruling, are we going to see a situation where they'll come up with their decision and defer the details, or we can expect to have all of that?
Right. We expect to have everything by the 42nd day. Now, the period is to provide them sufficient time to write.
Right.
In the last 2013 election petition, you discover that we had a judgment composite of nearly 600 pages. Now, every judge had to write their independent decision or opinion, and all of that had now to be what? Consolidated. So they need sufficient time. But even before they do that, you realize that, like Blay was referring to, the lawyers will also be giving time to now write what you may have become aware of as closing arguments, what we know in Ghana as the addresses. When the entire case and trial is over, the lawyers will now have to assess each testimony, each evidence, and then write in an argumentative way, submitting their case in a way urging the court that at the end of the case, we won. We produced this evidence. There was no contrary evidence to, as it were, rebut it. We made this testimony. This person could not rebut that testimony or didn't change the substance of what we said. And they'll be quoting the people who stood in the box. For example, the Electoral Commission was asked a question. Did you do this on this day as required by the law? Her response was that she didn't do it. Then the lawyers will add, once she answered that she didn't do it, and the law says she was supposed to do it, the law proceeds to say, if you don't do it, this is what must happen. Then they will quote, maybe the Supreme Court has earlier given some decisions using those certain principles. They will refer to the principles and say, dear judges, you have no option than to rule this way because this is how precedent shows the case must always be held. If it is the case that the law commands that something shall be done, and it is found that that thing was not done, the lawyers will refer to certain body of laws that says where shall is used, it is mandatory, and where it is not complied with, this is what happened. Then they can go to England, refer to cases, they can go to America, they can go to India, we all do it, and then we refer to cases where shall was required and something didn't happen,
right,
and the way the court ruled. So all of this will be done within that period, and the judges will receive all these arguments, and then they will also give their decision.
All right. All right, thank you very much, Samson Lardy. I'm sure the commentary and the analysis of the petition is going to continue for a while, and so we'll be engaging a lot more. But right now, that's what time will allow us, because we have to make way for another show that's coming up. And Joseph Akable, thank you very much for bringing us that enlightenment and for sharing with us the petition as you found or you obtained from the Supreme Court.